Hello viewers, the lesson of today is the sociological approach of Roscoe. Roscoe was an American pioneer of sociological jurisprudence. He was the leading exponent of sociological jurisprudence. According to him, sociological jurisprudence should ensure that the making, interpretation and application of law take account of social facts. Consequently, jurisprudence has assumed a new role that laws are to be made for men and the lawmakers and its executors are to take into consideration of human and the social aspect while making or executing it. Roscoe calls this approach to jurisprudence as social engineering. He described jurisprudence as science of social engineering. Roscoe, a biographical note. Roscoe lived a long and productive life. He was born in 1870 in Lincoln, Nebraska in United States. In 1901, he was appointed as an auxiliary judge of the Supreme Court of Nebraska. In 1903, he became the Dean of the Law School, Nebraska. He served successfully as Story Professor of Law and Carter Professor of General Jurisprudence at Harvard University and was Dean of Harvard Law School until he retired in 1916. He served for several years as University Professor at Harvard. Dean Pound has been a prolific writer in which he expounded from different angles the same fundamental ideas. Some of his celebrated works are The Spirit of the Common Law, An Introduction to the Philosophy of Law, Interpretations of Legal History, Law and Morals, The Formative Era of the American Law, Contemporary Juristic Theory, Administrative Law, its growth, procedure and significance, Social Control through Law, The Task of Law, etc. His prolific output with its propensity for classification is to a large extent consolidated in his 5-volume work Jurisprudence, which was published in 1959. Sociological jurisprudence, developmental perception. Sociological jurisprudence is 20th century development in legal thought. It may be noted that sociological approach to the study of law towards the end of 19th century did not emerge in isolation. It was a reaction and revolt against the barren formal approach of the analytical jurists and pessimistic approach of historical jurists. Both the analytical and historical tendencies had become counterproductive to social change and social justice. Moreover, the prevailing laissez-faire philosophy in the field of law and economics accentuated rift and confrontation between different groups and classes on several socio-economic questions, resulting in social disorder and economic injustice. Such a theory became untenable in the face of its outmoded notion of liberty without equality and freedom without security. This led to a shift from individualism to collectivism, wherein states adopted interventionist role and welfare policies, expanding their activities in matters of education, health, employment, insurance, old age, job security, etc. Hence, the new approach towards law in terms of its purposes and ends, functions and goals to regulate, order and control human conduct on a new basis emerged, which is usually described as sociological jurisprudence. From the point of view of historical perspective, the growth and development of sociological jurisprudence has been divided by Pound into 4 categories: the mechanical stage, the biological stage, the psychological stage, and the stage of unification. The mechanical stage. The French philosopher Auguste Comte is said to be the founder of modern positivism and father of sociology. He advocated a new approach to the study of society, which is described as scientific positivism. This approach is essentially empirical as opposed to metaphysical method, and is based on observation and experience derived from social facts. He further advocated the use of scientific methods to the study of social sciences by eschewing all the ideal and abstract notions. According to Comte, there are 3 successive stages in the evolution of human thinking: theological stage, metaphysical stage, and positive or scientific stage. The positive of scientific stage rejects all hypothetical constructions and confines itself to the empirical observation. Himself a mathematician, Comte's model of society was greatly influenced by mechanical mathematical analogies. The next stage in the development of sociological jurisprudence is the emergence of biological stage succeeding the mechanical stage. The biological stage is greatly influenced by the theory of evolution of Charles Darwin, which repudiates the claims of absolute reality or justice of the philosophical theory. Herbert Spencer made an attempt to explain social phenomena in terms of biological laws. He propounded the theory that law must evolve and change with society and with its progressive development. Likewise, Montesquieu, Henry Maine, and Vinogradov expounded the geographical, historical, and anthropological forces and processes to explain the origins and dynamics of law. The psychological stage is another development in the sociological jurisprudence. In this stage, the sociological jurists turned the attention towards psychology. The study of psychology made great stride as it greatly influenced social sciences, including law. Stage of unification. According to Roscoe, the last stage comprises 2 phases. An earlier phase, the unification of sociological methods, and the later phase, the unification of social sciences. Both these conceptions greatly influenced the sociological jurisprudence. The scope and purpose of sociological jurisprudence. Sociological jurists insist upon 8 points. They are the practical objectives of the study of law in society. Roscoe had given the program of sociological school as follows: study of the law in action, a study of the actual social effects of legal institutions, legal precepts, and legal doctrines, a study of the law in action as distinct from law in books, sociological study as a basis for lawmaking. The program called for socio-legal study as an essential preliminary step in preparation for lawmaking, sociological study as a basis for effective law enforcement, a study of the means of making legal precepts effective in action. It called attention to importance of not merely formulating desirable rules on paper, but of ascertaining by what means such rules can be made effective in the existing conditions of social life. Study of juridical method, study of legal reasoning and especially the judicial process in relation to legal development. A sociological legal history. The study of legal history in its social context, that is, study of the actual past relations of legal institutions, precepts and doctrines to the then existing social conditions. Study with a view to the individualization of justice. Recognition of the importance of individualized application of legal precepts. A reasonable and just solutions of individual cases. A ministry of justice. Establishment of ministries of justice in common law countries for the purpose of law reforms. The end of juristic study. The end of juristic study is to make effort more effective in achieving the purposes of law. Pound entrusts the jurist with a commission. He lays down a method which a jurist shall follow. He should study the actual social effects of legal institutions and legal doctrines. Study the means of making legal rules effective. Sociological study in preparation for lawmaking. Study of juridical method and a sociological legal history. Law as social engineering. Roscoe Pound linked the task of the lawyer to social engineering. The aim of social engineering is to build a scientific structure of society as possible, which requires the satisfaction of the maximum of wants and with the minimum of friction and waste. It is the task of the jurist to assist the country by identifying and classifying the interests to be protected by law. Roscoe Pound's social engineering theory is the American correlative to the German jurisprudence of interests. Roscoe Pound described the task of modern law as social engineering. By social engineering, he meant the balancing of competing interests in society. He observed, law is the body of knowledge and experience with the aid of which a large part of social engineering is carried on. It is more than body of rules. It has conceptions and standards for conduct and for decision. But it has also doctrines and modes of professional thought and professional rules of art by which the precepts for conduct and decision are applied and given effect. Like an engineer's formulae, they represent experience, scientific formulations of experience and logical development of the formulations, but also inventive skill in conceiving new devices and formulating their requirements by means of a developed technique. Thus, jurisprudence becomes a science of social engineering, which means a balance between the competing interests in a society. Pound's theory is that the interests are the main subject matter of law, and the task of the law is the satisfaction of human wants and desires. It is the function of law to make a valuation of interests, in other words, to select socially more valuable interests and to secure them. This all is nothing more than an experiment. That is why Professor C.K. Allen describes Pound's approach as experimental jurisprudence. Various steps in the process of social engineering. Roscoe Pound elaborated the most essential and important steps in carrying out the task of social engineering. They are inventory of interests, generalization and classification of interests, evaluation of those interests, selection and protection of interests, defining the limits, working out the details of enforcement, and formulation of jural postulates. The first step in the process of social engineering is identification of interests pressing for legal recognition. In other words, identification of the de facto claims or interests of individuals in their life. Generalize those interests and classify them into individual, public or social interests. The classification enables us to know the relative value of those interests. Evaluate those interests so identified to know their value at the given point of time. The value of interests is not constant. Their value varies with the changing social conditions. Then select the socially more valuable interests deserving legal recognition and protection. Define the limits within which the interests so selected can be legally secured. As it is not possible to protect one interest disregarding the other competing interests, the limits within which those interests are legally enforceable should be worked out. There should be an inbuilt mechanism for the effective enforcement of those interests which are selected for legal protection. Therefore, the details should be worked out for providing remedies and the enforcement machinery. And finally, the entire process of social engineering should be carried on in the light of jural postulates of civilization. It necessitates the formulation of jural postulates. Classification of interests. Roscoe Pound defined an interest as a claim or a want of a person or group of persons which the person or group of persons seek to satisfy. For facilitating the task of social engineering, Pound classified the various interests which are to be protected by law under three heads, namely individual interests, public interests and social interests. Individual interests. These are claims or demands or desires involved in and looked at from the standpoint of the individual life. However, it is proper to recall that such claims may also be stated as social interests. They play a vital role in social living and exist within its framework. The classification of individual interests adopted by Pound distinguishes three main groups. Firstly, interests of personality, which touch the individual physical and spiritual existence. Secondly, domestic interests, which affect the expanded individual life in the family. Thirdly, interests of substance, which touch the individual economic life. Interests of personality. This category includes interests in personal physical integrity, immunity of the will from coercion, immunity of the mind and nervous system from injury, immunity of the feelings and susceptibilities and the claim to privacy, honor and reputation, freedom of belief and opinion and their expression, etc. Interests of domestic relations. This category includes the interests of individuals in domestic relationships and of society in institutions such as family and marriage. Domestic interests are involved in two types of relations: parent and child, husband and wife. Interests of substance. This category includes interests of claims to control corporeal things, claims to freedom of industry and contract, claims to promised advantages, claims to economically advantageous relations with others, right of property, right of succession, right of association. public interests. These are claims or demands or desires asserted by individuals involved in or looked at from the standpoint of political life. These consist of interests of the state as a juristic person. This category includes the integrity, freedom of action, and honor of the state's personality, and claims of the politically organized society as a corporation to property acquired and held for corporate purposes. Interests of state as guardian of social interests. This category includes superintendence and administration of trusts and charitable endowments, conservation and protection of natural environment, protection of territorial waters and seashores, regulation of public employment to make use of things which are open to public use, etc. Public interests are interests of the state as such, the maintenance of its integrity and the maintenance of just balance between conflicting interests of the people. Social interests. These are claims or demands or desires in terms of social life and generalized as claims of the social group. Social interests are interests of the society as such. Pound enumerated 6 categories of social interests as paramount. They include social interest in general security. They include general safety, general health, maintenance of peace and order, security of transactions, and security of acquisitions. Social interest in the security of social institutions. This category consists of domestic institutions, political institutions, religious institutions, cultural institutions, and economic institutions. Social interest in general morals, which comprise provisions against fraud, corruption, gambling, prostitution, drunkenness, violation of trusts, etc. Social interest in the conservation of social resources. It covers use and conservation of natural resources such as gas, oil, mines and minerals, environment, food grains, forests, ecological balance, claims to aesthetic surroundings. Protection and training of dependents and defectives. Reformation of delinquents. Protection of economically dependents. Social interest in general progress. This has 3 aspects, namely economic progress, which includes freedom of use and sale of property, free trade, free industry, and encouragement of invention by the grant of patents. Political progress, which includes free speech, free criticism, free opinion, and free association. Cultural progress, which includes free science, free letters, free arts, promotion of education and learning, and improvement of aesthetic surroundings. Social interest in individual life, meaning thereby each individual be able to live a human life according to the individual's political, physical, cultural, social, and economic life. This category refers to self-assertion, opportunity, and conditions of life. The purpose of classification of interests is only to inspire consciousness in a political way of the values involved in a particular case. Such grading of interest should not be taken as rigid, or else the interests will lose their utility as instruments of social engineering. What is an individual interest? What is social interest? And what are respective weights or matters of changing political philosophy. The fact is that values of a civilized society are not absolute postulates, independent of time and social experience. They are constantly shifting. In days when analytical jurisprudence had no rivals in the field of legal thinking, judges used to boast of their aloofness from consideration of any matter other than law. Pound's elaboration of interests had caused a change in the general approach to law and has impressed on conscientious judges the need to inquire into the social facts underlying any legal problem and to maintain a fair equilibrium between competing interests involved therein. Jural postulates. The problem which juridical science has to face is the evaluation and balancing these interests. For facilitating this progress, Pound has provided what he calls the jural postulates of civilized society. He enumerated jural postulates of civilized society so as to know the value of conflicting interests. Every individual in civilized society must be able to take it for granted that he can appropriate for his own use what he has created by his own labor and what he has acquired under the existing economic order. That others will not commit any intentional aggression upon him. That others will act with due care and will not cast upon him an unreasonable risk of injury. That the people with whom he deals will carry out their undertakings and act in good faith. That he will have security as a job holder. That society will bear the burden of supporting him when he becomes aged. That society as a whole will bear the risk of unforeseen misfortunes such as disablement. That others will keep under proper control property that is likely to inflict damage if it escapes. That it is the responsibility of industrial concerns to make compensation for human wear and tear. That as a minimum matter, a standard human life shall be assured to every citizen. These jural postulates are to be applied both by the legislators and by the judges for evaluating and balancing the various interests and harmonizing them. According to Roscoe Pound, the content of law is determined by civilization of time and place. Law is a process of balancing conflicting interests and securing the satisfaction of the maximum of wants with minimum of friction. The claims, demands, needs, desires, wants or expectations of individuals in their life are not constant. They are changing with the changing social conditions. Therefore, law as an adjustment of conflicting interests in a society cannot afford to be static. In Pound's view, the function of law is to satisfy as many interests as possible. But how are we to know whether new interests qualify for recognition? He suggests that they might be tested by reference to certain jural postulates of civilization. Critique of Pound. 11 main sorts of criticism may be identified. First, Pound's classification of interests and accompanying jural postulates reads like a political manifesto in favor of a liberal and capitalist society. Secondly, his model of competing interests pressing for recognition and security overlooks the extent to which the law recognizes vested interests. Thirdly, he assumes that it is a simple matter to know the real interests of people, but we are all manipulated to a greater or lesser extent by advertising and other forms of persuasion. Fourthly, how do we actually set about establishing people's interests? Is it a matter of psychology or market research? Fifthly, should we in any event seek to satisfy people's wants? There may be good reason to protect certain interests regardless of whether people want them. Sixthly, his inventory seems almost irretrievably vague and nebulous. What, for instance, is to be accommodated by the social interest in peace and order or self-assertion? Seventhly, even if we read the list as helpful, it raises a plethora of difficulties. Is there really any fundamental distinction between public and social interests? Is the difference between individual and social interests crystal clear? Are the three types of interests equal in status? Eighthly, the idea of balancing notwithstanding, when it comes to a judge selecting between competing interests, each situation has a pattern of its own, and the different types of interests and activities that might be involved are infinitely various. It is for the judge to translate the activity involved in the case before him in terms of an interest and to select the ideal with reference to which the competing interests are measured. Ninthly, Pound assumes that claims pre-exist law, but certain claims actually result from law, for example, welfare legislation. Tenthly, what does it mean to recognize an interest? There is a gray area in which an activity may be permitted without being recognized by the law. Finally, Pound establishes his jural postulates by generalizing a value which is already legally protected. But if new claims are, as he proposes, to be judged by reference to jural postulates, they will be recognized only if similar claims already receive legal protection. This hardly suggests a particularly dynamic process of law reform. Critics are hard on Pound. Even though Pound undoubtedly exerted a considerable influence on sociological jurisprudence, he laid the foundation for an approach to law that looked beyond traditionalism to an alternative perspective rooted in law in action. This lesson is a moderate attempt to evaluate the contribution of Roscoe Pound to sociological jurisprudence.